Good afternoon, Reverend Mercer. You're live on Radio Jones. Thanks very much for joining us today.
Thanks.
Thank you. Let me just give you a brief introduction. Nicholas Mercer is assistant curating Gillingham and Milton on Stour in Dorset, and was previously last year, 2012, named as Human Rights Lawyer of the Year. So congratulations on that.
Thank you.
Thank you very much for joining us. As I say, I've asked you on today, Reverend Mercer, to fill us in on the alarming reports that we're seeing in the UK media about what are being referred to as the secret courts. Let me ask you first of all, if I may, what is the official reference term for the secret courts? How should we be referring to it?
It's called the Justice and Security Bill. It's received Royal Assent, so it will become law in the next session of Parliament.
Now that's imminent.
It is, yes. I mean, it's passed all the processes in the House, in both the House of Commons and the House of Lords, and has, as I say, the Queen's now, given her royal assent to it. Therefore, it will become law when Parliament resumes in the very near future.
Right. So the most recent hurdle it had to cross was the House of Lords, was it? Yes,
it passed there by just a few votes. I think there was something like 10 votes in it, but yes, it did pass through the House of Lords.
Right, now, give us a history if you can. Let's go back a little bit if we can, and ask you to fill us in for anybody who's not even aware of what these secret courts are or mean. How have they come about?
Well, that's a very good question, because they're not in any parliamentary manifesto. So much of government legislation has just emerged from wherever. I think there are two cases that have caused this legislation to be brought into being. These both are Guantanamo cases. The first is Binyam Mohammed, and the second is the case of Al-Rawi. And in both cases, the government was going to have to disclose details of how it was complicit in the rendition and torture of the two claimants. And there was an extraordinary amount of pirouetting in the courts by the government, who obviously resisted the disclosure of such evidence. It then went up to the Supreme Court, who said, well, I'm sorry, but there's no principle here of national security. I'm sorry, but you're going to have to disclose it, and at which case the government promptly settled the cases. So it was a result of these two cases where the government didn't want to disclose the evidence that led to the genesis of this bill. I mean, we've been fighting terrorism for 30 years in this country. Those of us who are old enough remember the IRA from sort of 1970 onwards, and we haven't needed these procedures at all. Come Guantanamo, then new legislation is required.
So you mentioned those two particular cases, though, both referring to Guantanamo. So under which government was this instigated?
Well, this comes under the Labour government, of course. This David Miliband was the first, whilst he was Foreign Secretary, was brought to court to explain himself, and there were all these arguments that it was all part of the special relationship and it would jeopardise the UK's relationship with the United States, and so on and so forth. But it was under a Labour government that this happened, of course, and of course, you've got the whole war on terror coming into being under Tony Blair's administration, and of course a lot of the people who are potentially implicated were in his government, and some of them are still serving. So it starts there, and of course it then gets taken up by the Conservative government when it comes into office. Now, some people might say, well, how does it pass from one government to another? Mm-hmm. Well, I think the answer to that is, well, of course, the security services. I think people forget that actually, although governments change, the cadre of civil servants don't change. And the suspicion is that it's the security services who are pushing this, or have pushed for this to come into law, and simply fronted up to the new administration and said this is necessary for national security, which of course is a complete misnomer.
Let's just qualify your comments there, if we could, Reverend Mercer, because you're not talking as a man of the cloth simply, or even just a civilian. You actually did serve under the Blair government in the UK military.
Well, I mean, yes, I did. Yeah, I joined the army in 1991, so I served under a number of administrations. One doesn't look at it like that. You simply joined the armed forces and therefore you are at the government's behest and you do as you're told by the government unless it's manifestly illegal.
But nonetheless, the reason I mention that is because it really does qualify you to know what you're talking about here.
Well, I came into, there is a whole narrative to UK complicity in torture from 1944 to date, through the colonial wars of Cyprus and also in Kenya and in Aden, then in Northern Ireland. The British government is implicated in torture in all those situations. In fact, there's a case going in the High Court at the moment involving the Mau Mau in Kenya. In Northern Ireland, the Irish government took the United Kingdom to court for the so-called 5 techniques, which were techniques used with prisoners who were being interred for the purposes of interrogation. Mm. And that was banned by the Heath government in 1978. But for my purposes, I was the lawyer for the Iraq War in 2003, where I came across the 5 techniques being employed again and put in an immediate protest that this was illegal. So I've sort of joined the narrative from there. And of course, that case resulted, ultimately the case of Baha Musa, which is very well known in the United Kingdom, exposed all that was going on. And again, a stop was put to these interrogation techniques. But as part of the wider picture, of course, are these cases coming out of allegations of complicity and rendition and torture, which are fairly widespread and keep coming. It's not just Guantanamo, it's sort of Libya and elsewhere.
Mm. We're on potentially. Let's maybe hope that we might be on some kind of brink in a change in what's happening at Guantanamo. Although one has to take with a pinch of salt what Barack Obama's words the other day, where he said he's going to take a new look. I, for one, won't hold my breath, and I'm rather cynical about it. And for one reason, perhaps in particular, Reverend Mercer, and that is because one has to imagine that if detention centres such as Guantanamo, which has been there for many years, which has seen a number of people go through it, still in there, detained for no reason, some of them cleared for release, have undergone torture, are currently on hunger strike and are being treated, as we understand from those reports from lawyers and human rights people who have access to them, who are being treated not humanely as those in the US military will tell us they are. Would we be right in assuming that there is some kind of reluctance on the part of the Obama administration to address this issue because of what will come out should those prisoners be set free?
That is one of the problems. There's a case in England at the moment of Sheikh Ahmed, who was cleared for release 7 years ago, is still in Guantanamo. He's only got 2 places to go. That's Saudi Arabia, which is his country of origin, or the United Kingdom. Now, it's very hard to get details that one can confirm or verify, but one of the allegations is that they don't want him to come to England because not only does he also have claims of UK complicity in his torture and rendition, but also implicating others at the same time. So those who are suspicious of these things believe that the UK government is pushing for him to go to Saudi Arabia in the hope that he might be locked up and these secrets might be locked up with him.
But that despite the fact that
that's a real difficulty, because if you take that in one individual case, which it happens to involve the UK, then of course the British government's in a really difficult place because it doesn't want him back here, but it wants to appear publicly to say that, whilst behind the scenes perhaps wanting something entirely different.
Just last week, there was a parliamentary meeting and protest in the continuation of the campaign for his release. And if I'm not mistaken, he actually does even have a child in the United Kingdom. So it seems that his human rights in that respect are being overlooked already. The guy is still in detention. But there was a meeting and a protest last week. Now, there are a number of MPs who are fighting courageously to get the right thing done by Shaka Amar, but is it not a little bit questionable that this bill, the Secret Courts Bill, could have been passed through Parliament when there are MPs who would one would have hoped would have managed to vote against it and not allow it to go through? Or are we to understand then that the UK military, the secrets, or maybe not the secret, but the security services have more power than we'd like to admit?
Well, I mean, again, it's hard to judge, but I mean, I've seen his work in the military where the civil service have come into a senior commander and said, "Sir, we need to get this done." And who is the commander to judge when he's just come into office or into his military post, when he's got a long-established civil servant there with years of service and practice behind him? It's very hard for him to second-guess that with no prior experience. So I think there is a really important issue there about who's running who in all of this. Mm-hmm. But I think there are some more important issues as well. First of all is that if the security services are implicated in this, then they can bring forward a bill that could potentially cover their tracks. So they could. I mean, I'd be very, very surprised if the security services weren't involved in the drafting of the Justice and Security Bill. So in a sense, a civil servant can put forward a bill and get people and put in the clauses that he or she wants, mm-hmm. And then hand it to the minister to pioneer through the House. The next thing, of course, is those who were part of this process of this rendition and complicity and torture. Of course, some of them are still serving in government. Jack Straw, of course, is under investigation for the Libyan, Mr. Belhaj and al-Sadi, because he denied the renditions ever taken place. And, of course, now we know that he did and that he lied to the House of Commons. But, of course, he's able to help steer that through the House of Commons and also vote on it himself. And he's got a vested interest in voting in a particular way. There may be all sorts of political deals being struck. So too in the House of Lords, where security service chiefs still sit. You know, they're voting on a bill which potentially they're implicated in or have a vested interest in ensuring these things never see the light of day. And I think there are really difficult constitutional issues. I mean, Dame Manning and Buller has said, "I'm not prepared to comment on this whilst an investigation is going on into it." But at the same time, we're passing a bill that could cover it all up. I think there's another issue, which is those who've inherited departments where their staff are potentially implicated, also caught in a difficult place because they've got to run their departments with staff who'd be pretty disgruntled if they voted a particular way. I think it raises all sorts of issues about the way Parliament does business.
It certainly does. Now, regarding the secret court, the controversial plans to introduce this, some significant number of lawyers, UK lawyers, have actually objected to this, and also judges, even to the point of suggesting that perhaps judges would refuse to sit in these courts.
Well, I think how it's going to play out is going to be very interesting. There were 700 lawyers signed a letter, including 40 QCs, objecting to the secret courts bill. So a substantial number. That's 40 QCs and 700 lawyers. The special advocates, who are the people who will have to make this work, described the system being proposed as inherently unfair and contrary to the common law tradition. I mean, I think something like 90 or 95% of them are opposed to it. A number of judges have spoken out. Lord Kerr said, evidence which has been insulated from challenge may positively mislead. And another, Lord Hope, who's Deputy President of the Supreme Court, said, secrecy cuts across absolutely fundamental principles, such as the right to be confronted by one's accusers and the right to know the reasons for the outcome. The former Director of Public Prosecutions, Ken MacDonald, said that it's a smokescreen for plans which, this is Ken Clark's comment about it, we won't have, it's wrong to pay compensation. And he said, this bill is to spare the embarrassment of the security services when they get mixed up in wrongdoing. I mean, the voices are all over the place and plentiful, and from the people who are right at the heart of the system.
What about Ken Clark's involvement in this? That's an interesting one. I mean, he lost his job as Justice Minister last year, as I understand it. So he's a minister without portfolio, but still has been very important in rolling this through to the point it's at now.
Yeah, sure.
Why?
It's got me baffled. I don't know. You'd have to ask him. I mean, he's been a fairly vociferous advocate, and he's traditionally associated with fairly liberal values. And I think, to be perfectly frank, there are a lot of people who just disagree with him, full stop.
Good Lord. That's extremely worrying. Can I ask you, Reverend Mercer, without wanting to minimise, obviously, the importance of this when it's specific to renditions of torture, but let's bring it to a more civilian level, if you like, and tell us what a secret court means for an individual, because this isn't just about covering up torture which has taken place in a prison which is on an island far away and is meted out to those who the government tells us are essentially potentially going to endanger our lives. This can actually be applied to us as individuals as well.
Well, I think if you were a claimant in such a case where this what's called closed material procedure is applied, the implications are as follows. First of all, you can't have the lawyer of your choice. So if you've got a claim and you want to bring a claim, say, against a company or a holiday rep or something like that, you go down to your high street and choose the lawyer of your choice, and he or she represents you in the court. In a case that involves the security of the country, you can no longer have your own lawyer. The government appoints one for you, called a special advocate. And then you can't, in normal case, you get disclosure in a trial. So you'd say, look, I'd like to see X, Y, Z, please. And in most normal circumstances, the court orders the other side to disclose the documents. That's simply so you can prepare your case, and they can't hide the documents from you, because very often that will decide who's telling the truth or not. Not anymore. You can't in secret courts. You're not even allowed to see the evidence which is being presented by the government against you. So you can never challenge it, nor indeed can you see it. The special advocate, your government-appointed lawyer, can't even take your instructions on that evidence. So you could find judgment given against you on the basis of evidence you've never seen, is not referred to in the judgment, which you can't challenge. So this really does, the Human Rights Committee of the House of Commons described this as Kafkaesque. It's sort of reminiscent of Franz Kafka and the trial. So you'll never know the evidence. Now, I think that in itself is particularly alarming. I don't know if you saw that recent Panorama program on the dodgy dossier that took us to war in Iraq.
Yes.
This is the evidential sort of stuff of the security services. It comes from all sorts of really dubious sources. I mean, one of their sources, which got fed into the dossier for the case for war in Iraq, was a taxi driver who overheard a conversation in the back of a taxi cab. One of the key witnesses in this whole road to war was asked by Panorama and said, so we went to war on a line. He grinned and said yes. He wanted asylum in Germany. So he had every motive to tell the security services whatever they wanted. Now that's bad enough, but that sort of evidence could now decide the case in which you or I or anyone else could find themselves bringing against the United Kingdom government. So not only is it a disgrace that you can't see the evidence, not only is it a disgrace that you can't challenge it, but we know from past history that an intelligence-based evidence is inherently unreliable and should be subject to the strictest scrutiny which only an adversarial system can bring. But now that's shielded from challenge, and one can only imagine the miscarriages of justice that will emerge from it.
Well, it makes a total mockery of what we refer to as the justice system, and it begs the question, why do we need a justice system?
Well, I agree with you. I mean, this is a really retrograde step.
Why are we now at a
point? Well, this is designed to shield the British public from details of rendition and complicity in torture. We overstepped the mark in the war on terror. We went over to the other side. The Americans lost their bearings. We were stuck in the middle of it with everyone else, and a lot of other countries have been involved in it too. We're not alone in rendition. But if you think of one of the cases, I think one of the Libyan cases, this wasn't. I think this is the case of Mr. Belhaj. It's bad enough that a so-called, someone who the intelligence services believes is a terrorist is rendered and sent off to Libya and sent off to their chief torturer. But it was his wife and family too. His wife was shackled to the airport wall. His kids get rendered. Sir Mark Allen, the head of MI6, writes a letter to Gaddafi's chief torturer saying, "Oh, by the way, I hope you're pleased with what we're sending you." This is an absolute scandal. And I don't want to sound overly pious, as but actually I do believe that we all have wars to fight and we have the security of the nation to consider, but you jolly well do it according to the rule book.
Well, clearly that rule book is being perhaps potentially ripped up and thrown out of the window as we speak now. How do you see this, Reverend Mercer, in terms of the imminence of its usage? The Queen...
I think it's fundamentally flawed, and I'll tell you why. Because first of all, I think that allegations of torture are going to come up all over the place. They're going to pop up left, right, backwards and forwards, inside out. If it doesn't appear in the secret courts, it'll appear in the European Court of Human Rights, and so on and so forth. But of course, there are cries to get rid of it. That is our obligations under the European Convention on Human Rights, which I'm sure is in part driven by this fear about what it might disclose about UK security services. But I think there's an internal contradiction in the bill, and that's the difficulty, that if a special advocate discloses evidence of torture or is party to evidence of torture, I would have thought that advocate is professionally obliged to bring that to the attention of the judge, and for the judge to then take such action as he or she sees fit. And that would mean handing the evidence to the DPP. And I'm not sure how that's going to operate, because if the evidence can't be challenged in court, I think if there's an allegation that someone's been complicit in torture, that would have to be investigated prior to the special court continuing. So I think there's going to be real difficulties in getting this to operate in practice. I think there are other difficulties. Both the Professional Bar Association and the Law Society have objected to this bill, because advocates who can't take their clients' instructions may be breaching their own professional code of practice at the same time.
But then there would always be, one assumes, advocates who would be willing to play the game as was required.
Well, if you say play the game, you've still got a professional code to stand by. And,
if we're talking
in Guantanamo, where military lawyers have had to defend clients, there have been all sorts of attempts by the military to make the advocates behave in a certain way, and the bar associations have stepped in to ensure that they behave according to their professional standards and not the standards required by the state. So I think there are all sorts of problems ahead, and quite rightly so.
And what about international parallels? Are there? Can you give us examples of other nations that have gone down this road of justice?
Well, I think I haven't done a comparative study, nor do I practice law to that degree anymore. But certainly Sweden was implicated in allegations of rendition. In fact, the CIA and the Swedish authorities rendered someone to Egypt. And the Swedes dealt with it in the following way: that the Parliament met, they realised that this was a breach of international law, and they put provisions in place to ensure that it never happens again. And that's what we should be doing, rather than covering our tracks for another generation. We should acknowledge that this has happened, we should acknowledge that it's wrong, and rather than cover it up, we should say, right, now we're going to ensure that this proper legislation is in place, that this can't happen again, we can't overstep the mark. As it is, however, and I suspect partly because Guantanamo is still open, we're taking the other step and seeking to cover it up for a generation. And I think there's another supreme irony in all of this, is the fact is that the Mau Mau case is currently going through the High Court. So despite years of resistance by the government, we're finally uncovering evidence of torture and complicity and torture from the colonial period and bringing it out into open court. But this generation's misdemeanors are being put into the most secret file, and the door slammed shut, hopefully, I imagine, hopefully for the people involved, for the next 50 years when we're either in nursing homes or in our grave.
But what's most fascinating is something that you mentioned right at the beginning, and that is that regardless of what government happens to be, what elected government happens to be in power at that moment, the cover-up of these allegations seems to be unanimous.
That's certainly the way I see it.
Reverend Nicholas Mercer, Assistant Curating Gillingham and Milton on Stour in Dorset. And I must just thank you very much indeed for your time today on Radio Jones. It's been fascinating, and I hope we can speak again.
Thank you very much.
Thank you. Bye-bye.
Bye-bye.